Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain eviction laws in Kansas and how to recover your property in 5 simple steps. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks or physically remove a tenant themselves. So if the renter refuses to leave after violating their lease, you must seek an eviction from the court. The process for simply terminating a lease differs from that of an eviction. Lease terminations require proper notice from the landlord or tenant, and state conditions can be found on our website. Legal reasons for eviction in Kansas. A landlord only has grounds to evict a tenant for reasons allowable in the state. The first step in the eviction process is to give the lessee one of the following notices. Non-payment of rent. If the tenant is late on rent and has been renting the property for less than 3 months, you can serve them a 3-day notice to pay or quit. This gives them 3 days to pay rent in full along with any penalties or vacate the property. If the tenancy is 3 months or longer, the lessee must be given a 10-day notice. Non-compliance. If your tenant violates the rental agreement, a 14-day notice to comply or quit gives them 14 days to abide by the lease. If they do not fix the issue by the end of the 14 days, they must vacate within 30 days. If the tenant violates the agreement twice in the same way within 6 months, they can be given a 30-day notice to quit with no option to cure. Rent grace period. In Kansas, there is no rent grace period. Rent is due on the due date. An eviction notice can be served if rent is only 1 day late. 5 steps to legally evicting a tenant in Kansas. Serve the notice to quit. Choose the form you need and download or fill it out on eForms.com. Post it on the tenant's door and also send it via certified mail with a return receipt requested via USPS. If the notice is mailed, an additional 2 days must be added, and if the breach is curable, you must wait for the specified number of days to give the tenant a chance to fix the problem. File eviction papers with the court. If the tenant hasn't mitigated the issue and remains on the property, or if the breach is incurable, you can proceed to court. You'll need to file a civil information sheet and a petition for eviction. The petition for eviction must be signed by the landlord in the presence of a notary public. These forms need to be filed in the district court where the property is located, and you'll need 2 additional copies of each form for every tenant. Serve the complaint. After the filing, the landlord will need to obtain a summons from the clerk, 1 original and 2 copies. This, as well as a petition for eviction, must be served to the tenant by the county sheriff. Attend the hearing. The court will set a hearing date. If the tenant doesn't respond or attend, or if the judge rules in your favor, a judgment will likely be issued that orders the tenant to vacate. After the hearing, you must complete the journal entry of judgment, of which you must send 2 copies to the tenant along with the certificate of service. Removing the tenant. If the tenant is ordered by the court to leave and they do not vacate, you may file a writ of restitution. After obtaining the writ, you may call your local sheriff's department to remove the tenant and their possessions. Damages. Often the tenant's security deposit does not cover total losses. If damages are not awarded at the hearing, you may be able to recover past due rent and court fees through small claims court. Now you can get eviction proceedings started. Get eviction forms, court documents, and all other information that you'll need at the link below for free.